This is Bloomberg Law with June Grasso from Bloomberg Radio.
We have a right, like every country in the world has a right, to remove you from our country. So it's just that simple.
And Secretary of State Marco Rubio said that under his direction, at least 300 visas, primarily student visas and some visitor visas, have been revoked.
Why would any country in the world allow people to come and disrupt? Now, we gave you a visa to come and study and get a degree, not to become a social activist that tears up our university campuses.
Rubio acknowledged that he revoked the student visa of a Tufts PhD student due to her views on the Israel-Hamas war. My guest is immigration law expert Leon Fresco, a partner at Holland & Knight. Leon, Rubio said, if they're taking activities that are counter to our national interest, to our foreign policy, we'll revoke the visa. Are most of the student arrests that we've been hearing about due to revoking their visas, due to a revocation of their visas?
Well, yes. So there's two steps in the visa revocation process. There's a first step where what can happen is you have a visa, you enter the United States, you're here legally, and you get an email from the State Department. And this actually is quite common. It's not just about this issue. It happens if someone gets arrested or for other issues. You'll get an email from the State Department that says your visa has been canceled. And what that means is that if you leave the United States, even though you have this thing in your passport which says you can travel, let's say, through 2028 or 2029, when it actually gets swiped, it won't work. It's canceled. That doesn't mean just because your visa has been canceled that you have to leave at that moment. It just means that you are subject to being told you have to leave. So then there's a second step, which is if the government actually wants you to leave, then ICE has to actually come and place you in deportation proceedings to say, because your visa was canceled and we don't think you have a right to remain in the United States, we're going to place you in deportation proceedings. That's the new one that's happening more often now than ever happened before. Before, you were just told if you left, you couldn't come back. But now people are actually being affirmatively placed into removal proceedings that are trying to get an outcome where they actually are forced to leave the United States.
Now, the Palestinian student at Columbia who was arrested had a green card. Do we know if there are a lot of arrests involving green card holders?
We now know of a handful of those, of students who have green cards. There was a South Korean student who also was at Columbia who also had a green card. And there are a couple others where what's happened is for those individuals that have green cards, it's much harder. You can't just give them an email canceling their visa because there is nothing to cancel at that point. You actually have to say that one of the grounds of removal in Section 237 of the Immigration and Nationality Act actually applies to this person. And so usually what you would want to say is that they did something where they supported terrorist organizations, and that's why they were going to be placed in removal proceedings. But here they're trying to skip that step because they don't want to actually have a trial in immigration court about whether you supported terrorists or not. They want to try to rely on the provision that says that if Secretary Rubio says that your very existence and presence here in the United States is bad for American foreign policy, then he can just order you deported. He doesn't actually need to prove anything in that situation. And so that was the ground that was originally used for Mahmoud Khalil, the Colombian student. And supposedly they've added some others now. We'll have to wait and see how that plays out. And it's unclear because all of these are private documents. Unless the foreign nationals want to release them to the press, then nobody sees them. So it's unclear what some of these other students are being given. But if they are being given this category where Secretary Rubio is saying that it's against the foreign policy interests of the United States, well, in that situation, then theoretically there's going to be a lot of litigation about whether you even get a trial here or not. And that's where the courts have really not given us any idea yet. I mean, there was a case where when President Trump's sister was alive, she said that was an unconstitutional provision that couldn't be applied. But that ultimately didn't make its way into an appellate court legal precedent. And so we just don't know how that's going to be resolved when it gets to the courts.
Well, let's talk about Mahmoud Khalil for a minute. The New York federal judge ordered that his case be transferred to New Jersey, but it hasn't been transferred yet?
Well, what happened was the New York judge, Jesse Furman, said, I'm ordering the case be transferred to New Jersey. And he actually, oddly enough, still claims to have an injunction, even though he's transferred the case. So unclear who enforces this injunction that prevents the removal of Mr. Khalil while his case is pending. So he put that injunction in and then transferred the case. But then there was a hearing in a New Jersey court. And so there's a judge there, Michael Farbiars, who had a hearing in New Jersey. And there was a dispute between the Department of Justice and Mr. Khalil's attorneys. Mr. Khalil's attorneys want him to have that jurisdiction in New Jersey, and the federal government wants them to have that jurisdiction in Louisiana. And so that issue has not yet been decided by Judge Farbiars in New Jersey.
It seems like in a lot of these cases where students are being detained by ICE, there's very little or no information about why they're being detained. So, for example, in the case of a University of Minnesota graduate student being detained, officials in Minnesota, including the governor, are asking why.
So here's what happens. So the foreign national who's detained is supposed to be served at that moment with a warrant and with a document called a notice to appear that explains why they're being apprehended and what the ground is that they're being placed in removal proceedings for. Now, how that document then gets transmitted to the rest of the world becomes a problem, because if the person then gets put in a detention facility, they would need to have access to a fax machine, or a lawyer would need to come down and make a copy of that document in order for anyone else to find out what is in it. And so that's why people don't know, because until finally that person who is detained ends up making human contact with an attorney or someone else, no one will know anything about this person's case.
And can a person even get a hearing for cancellation of a visa?
It's going to depend what the grounds were for removal. There's a thing called INA Section 214B. It's like a catch-all provision that says if we don't think you're doing the things you're supposed to be doing here on your visa, we can cancel your visa. So if the Secretary Rubio is canceling visas pursuant to 214B, then what can happen in those visitor visa cases is that the reason for the removal is just that you have a canceled visa, and that's it. So then you would just have a case about whether your visa was canceled, and the answer would be yes. So in those situations, there's not really anything to have a hearing about for those people, and they will lose. But that cannot be done to the green card holders. So for the green card holders, an actual ground of removability is going to need to be asserted. And so for that, if it's terrorism, then there will need to be a trial in immigration court about terrorism. Or if it's some other ground of crime, then there will need to be a trial into that. The only one where there will be an argument about whether a trial is valid is this issue of whether the secretary thinks your presence is contrary to the interests of U.S. foreign policy. And that's where there are these habeases being filed saying, look, they're trying to preempt this argument, saying you can't put me in a process where I don't get to have some sort of due process and trial, or that statute in and of itself is unconstitutional because it can be used without any guardrails of any kind, meaning it can just be used on anybody for any reason. And if that's true, is that really what Congress intended there?
And so their best bet is then challenging the constitutionality of the statute?
Because really, at the end of the day, it's hard to have a trial on whether the Secretary of State should think or shouldn't think that your presence is contrary to the interests of foreign policy. That's a tougher one, because how are the courts going to substitute their judgment for the Secretary? It seems like the more promising argument there is just that statute is unconstitutional because it's too vague and it's basically a violation of someone's due process rights because there's no way to get yourself out from under such a thing. The only thing there will be, how does one challenge that? Can one challenge that preemptively like the people are trying to challenge, which I think they're finding sympathetic judges right now, but most likely that's going to be viewed as not valid What's probably going to happen is they're going to have to go through the removal process and then challenge it at the end as what's called a petition for review of a final order of removal. And then the courts will get to these cases and decide whether those statutes are constitutional or not.
There's been a lot of litigation over the hundreds of Venezuelans, alleged gang members, deported to prison in El Salvador. Where does that stand?
So there's currently an injunction that was issued by the district court in D.C., Judge Boasberg, and that's actually been affirmed 2-1 by the Court of Appeals of the D.C. Circuit, that says that you can't deport anyone using the Alien Enemies Act. And there's actually a different injunction issued by a different court which says you can't do these third country deportations, meaning you can't send people to a third country just willy-nilly without giving them some ability and due process to challenge that removal to a different country. Those two injunctions should operate theoretically to prevent deportations to El Salvador right now of Venezuelans. But there was just a deportation today of 17 people to El Salvador who were claimed to be Venezuelan gang members. The interesting question would be whether those people all had final orders of removal and were not Alien Enemies Act deportations, whether they were people who could have been deported. And then the question also is, did this deportation violate this third country removal injunction that was issued? And so that's going to be an issue that's going to be scrutinized as well. But we're going to have to see where these new 17 people who were deported fit into this puzzle and whether an injunction was actually violated there.
Coming up, panic about traveling among green card holders. This is Bloomberg. There's a lot of litigation concerning the deportations of alleged Venezuelan gang members to prison in El Salvador. A federal district court judge has put a temporary halt on the deportations, and a federal appeals court has upheld that order. And now the Trump administration is asking the Supreme Court to allow it to resume deportations of the alleged gang members without hearings. I've been talking to Leon Fresco of Holland and Knight. So Judge Boasberg ruled that the Trump administration can't deport the 5 Venezuelan plaintiffs in the case. What about the Venezuelans who are already there?
Well, that's going to be an issue for later this week. The court is going to have to decide the fate of those individuals and whether those individuals can be brought back to the United States. And also, the Supreme Court is also being asked to weigh in on this injunction, and they're being asked to stay this injunction so that more deportations can happen in El Salvador. So we're going to have court rulings coming from both directions, both from the Supreme Court and from the district court on whether its injunction means that it should bring people back to the United States, and the Supreme Court on whether all of this was improvidently done and the Trump administration can continue just as it started, deporting whoever it says is an alien enemy into these prisons in El Salvador.
And also, attorneys hired by the Venezuelan government have filed an action in El Salvador to get the imprisoned Venezuelans released or transferred and repatriated. The question is whether there's a basis for holding them even under El Salvador law.
The issue here is the following. Both El Salvador and the United States have similar laws which say that at the end of the day, you can't have people in detention if they didn't actually commit a crime and were punished for detention, unless the purpose is to create some sort of very minimal backstop in order to secure the removal of individuals. And so the question is for El Salvador, why are these individuals being detained in El Salvador? If they can be moved quickly to Venezuela, then the point from the Venezuelan standpoint is these individuals should be moved because there's no basis for El Salvador to be detaining these individuals. They were not punished for any crimes they committed in El Salvador, and they did not actually commit any crimes. There's no reason legally that the El Salvador government would be detaining them. And so that's the issue that the Venezuelan government is going to try to get to. But then the issue is, does that mean that Venezuela is going to agree to start taking these individuals? And if it does, then it'll have a much stronger case. But if it doesn't agree to start taking these individuals, then what El Salvador would say is, we can't have these violent gang members free in El Salvador. They will create instability in El Salvador. So we have no choice. If they're going to be deported here, we have to have them detained until Venezuela agrees to accept them.
There are about 12.8 million green card holders living in the United States. And there are a lot of concerns with these high-profile arrests of some green card holders, including at least one who was returning to the United States and arrested at Logan International. And there are reports of, shall we say, stepped-up activity at the airports by Customs and Border Patrol?
There is much more press scrutiny, for sure, being given to airport action. Statistically, the numbers are still pretty low just because there's only so much capacity at these airports to be doing this. The airports are taking in tens of thousands of people a day on these flights, and they're detaining, at the end of the day, a handful, maybe 10 or 20 individuals per day. But these 10 or 20 individuals per day, some of them have become very high-profile cases recently. French scientists coming for conventions, British tourists, Canadian tourists, German tourists, who aren't people typically detained at these facilities. And moreover, the problem is it's very typical for the Border Patrol when they detain someone to take their phone and to basically find what's in their phone and see if there's something in their phone that's incriminating. And so there's much more this sort of stuff coming out in the news where they say that the CBP found something on the phone. And this is creating a lot of nervousness from people traveling into the United States. What I would say is this, which is statistically, traveling into the United States is still 99% of the time not going to be a problem for most people. But if you are traveling in, for instance, one of these visa waiver program situations, which is that you don't need a visa, many people have used these programs who may have done something slightly questionable. They've worked, or they're married and they're traveling, they're married to a U.S. citizen. If there's anything questionable like that, and it's not a truly normal visit where someone is just going to Disney World, or they're going for a brief trip of a business convention or conference or something like that, if there's something more to it where there's a work component involved, or the person is somehow trying to skirt just the normal travel, those are the people that need to start being a little bit more careful about what they're doing, because the CBP is letting a lot less of that slide than previously.
Permanent green card residents, are they questioning them at the airports too?
So if you're a lawful permanent resident of the United States, you are entitled to be admitted into the United States. The only times where this gets a little bit tricky is there are people who have had convictions from maybe 20 or 30 years ago that don't realize that those convictions are deportable offenses. And when they're traveling in, they're now being told, hey, you have this deportable offense in your background. You're going to be placed into deportation proceedings. There's some of that. But also, look, if you are one of these people that's subject to a random inspection, and then they find on your phone all kinds of stuff that's very questionable for the purposes of what the government is finding questionable these days, then they could potentially say, look, this is a person who is someone that Secretary Rubio wants to then say is subject to the foreign policy exception and should be deported. Now, that person might be detained for a while before such an exemption is made. And so that is theoretically possible in those situations. And so what does that mean? It means that it's a different environment for travelers now, and travelers need to start assessing, are they at high risk based on things they've said or done in terms of the priorities of this administration. And that's definitely a new frontier that didn't exist previously.
It's a lot to take in. Thanks so much, Leon. That's Leon Fresco, a partner at Holland & Knight. Pop singer Dua Lipa has won a second copyright infringement lawsuit over her mega hit Levitating, which became a viral sensation used on millions of TikTok videos. The plaintiffs accused her of copying two disco songs, their 1979 song Wiggle and Giggle All Night and their 1980 song Don Diablo. But a judge tossed the lawsuit, granting summary judgment after finding that the plaintiffs failed to back up their allegations that Levitating was substantially similar to the protectable aspects of their works. Joining me is entertainment attorney Ronald Beanstock, a partner at Scarinci Hollenbeck. Ron, start by telling us about the first copyright infringement lawsuit Dua Lipa won involving a reggae group.
Always my favorite topics because, these are relatives calling you, sending you texts. Hey, man, what do you think about this kind of stuff? Everybody has all the layman's versions of these things, but there's some deep dive on some law and also facts. There's a 2017 song by a relatively, and I don't want to insult anybody, but relatively unknown reggae group in Florida. And this first case, the first infringement case, was that you got to prove access, as you know, in all of these cases, two-step process. The giant hurdle is access. Then you've got substantial similarity. If you don't have access and you can't really prove it, you can't say somebody heard of this or it was a hit, someone should have heard of it, or you were on tour with them, or you shared the same manager, or you shared the same producers, or all those different check the box for access, then you got to have some striking similarity to go further. And that's where the federal courts usually go, okay, there's your bar, right? And this isn't strikingly similar. So back to our reggae claim. So you've got effectively a four-chord pattern that is in minor key, the song Levitating in B minor. And the chords sort of match up, but that's not how this works musically. If you don't mind me singing, I hope I don't ruin everybody's day.
Go ahead.
But there are two things that are very clear in both cases involving the song Levitating. It's this pattern. Da-da-da-da-da-da-da-da-da-da-da-da-da. Descending, chromatic, across the four chords. Here you go. Da-da-da-da-da-da-da-da-da-da-da. And that's going to be what somebody's got to hang their legal hat on and say, that is not a common element. You don't hear that very often, and these things match up. When you do the analysis the way we do in court, when we take these melodies and we put them into the key of C or you match them up in the relative key, those notes are going to match up. And then they talk about harmonic, styling and all these. Well, that's staying alive. Da-da-da-da-da-da-da-da-da-da-da-da, right? We've heard that before. So immediately when you start seeing the judge saying Mozart and Gilbert and Sullivan, and mentions the Bee Gees, starting with Mozart, that's a pretty common element. So when people say, hey, I've heard that before, sure you did. You heard it probably 6 centuries ago. And the Bee Gees, da-da-da-da-da-da-da-da-da-da-da-da, hey, stay alive. These are sort of common elements. So the first part is that the plaintiffs in the first case involving the reggae band couldn't prove access. And then it really fell apart once you start talking about common elements. These two things sound so much alike and they're strikingly similar. And it got dismissed. And that was the end. And if I'm to give you one more pop culture reference, the chords are the same things to ELO's Evil Woman. These are common and four-chord patterns in songs. We could be here all day. I mean, they're really common. So the first case really rested upon, if you will, and dismissal rested upon the idea that you had no access, and they're not strikingly similar.
So we go from reggae to the second case, which involves two disco songs.
The second case is interesting because I think this was a slightly more sophisticated approach to it, right? They saw it kind of didn't work on the first matter. They have that precedent. So now you can kind of roll into, well, what should we do that's different here? Still the same issues. It's in B minor. And now you have this 1979 Wiggle and Giggle in E flat major. And then this Don Diablo, only in Spanish, sung in Spanish, also in a major key, B flat major. So you already start with some variations, right, getting started. The other thing that the layperson generally, and they discuss this with me, and I'm sure discuss this with you, is it's about publishers. This is not about Dua Lipa. This is about the publishers. The lawsuits involve who controls the copyright. So these are major publishers, Warner, Sony, Universal Music. So they're going to get some really powerful teams of really experienced copyright lawyers I know some of these people, they're great at what they do. They've been through this before. So you start already with the concept of, all right, where's our access? Where's that giant hurdle? You got to get over a 1979 disco tune called Wiggle and Giggle, and then you have the Spanish-only Don Diablo. When would these writers, there's 4 writers, it's not just Lipa, when would these people have access to that song? So that's a huge hurdle. If you don't prove that, you're right back to this, what's strikingly similar. So the plaintiff said the opening melody was duplicated throughout the song and gave a retro feel. Well, okay, that doesn't count. Retro feel is not substantive. Again, we're not talking about the copyright and the sound recording. This is where the average layperson falls off the cliff on this. We're talking only about the composition. The idea that things may sound similar because they're of the same beat and other elements, not controlling here. It's the song. So you had this claim that the opening melody was duplicated, and then the defense was, well, wait a second, these are non-copyrightable elements, just like our last case, right? Common elements, common 4 chords, and that common descending pattern of da-da-da-da-da-da-da-da-da-da-da-da. And so these are not enough to prove it's strikingly similar. And the judge dismissed and said, no, I'm giving you summary judgment to defendants. And I took a look at the experts, and we had the Daubert claims about whether they were acting as experts in their opinion, all the infighting that go on in federal court about experts and copyright. But ultimately, the judge said, hey, these are common elements. I can't let this case proceed. And she dismissed using summary judgment.
Some are saying that this case benefited from the precedent set in the Ed Sheeran case.
All right, so the Ed Sheeran case, it went to verdict, right? It was not decided in a summary judgment or dismissal. The jury got to hear Ed Sheeran play his song in his version live. That, to me, was an error by the plaintiff, because then he got to interpret any way he wanted in front of this court how he would present that song. So that's a problem with just the presentation of evidence and control of that. The second part was, throughout his case, they said there are some common elements in music, right? There are common patterns and common things. You don't own an idea for a song. And that runs 2 ways. One, it's the sound recording, which is the problematic cases always have the idea that someone got to hear it. That's not what we're talking about. Big X through that. Only talking about the song. So if you have a song that has common elements, we're not talking about other audio similarities. We're just talking about the common elements in the composition. And yet you can't prove that these common elements are listed, right? They're not protectable. Then you get the same result that you had with Ed Sheeran, right? They're not protectable. He has his own interpretation of that. It does not match up to your claim. And so eventually that case went its way. So the common element theme comes to play in all 3 of these to some extent. The first one really was just based upon no access at all. So you kind of get that running through all these cases. Those are all Southern District, are all here in New York, so you can get the same circuit decision, you get some unanimity as to the decision making.
What does it say about the song if you have 2 different copyright suits?
It says that the song made a lot of money, and no one would care unless it made a lot of money. So this is a popular artist, and everybody wants a piece of what is to be a hit. And, all we got to do is talk about the Mariah Carey lawsuit, and we're rolling right into that theory. But everybody wants a piece of something that's been popular or stays popular or has some type of longevity as a hit. I don't know if this song stays in the world of longevity of hits or not. That magic 8-ball answer I don't have. But these lawsuits just don't happen unless there's money and real money involved. And every time there's a hit, you're going to have a couple of different issues here in income streams from music publishing. There'll be performance royalty income to the writers and publishers. You're going to have synchronization licenses for a successful song that gets onto TV and film. You're going to have, you start with radio, now you're down to film and TV. You're going to have that song placed in movies and TV shows. There's mechanical income from downloading. If you sell the physical vinyl, or if they're still selling CDs, I don't know if it does that anymore, but if they did, you have mechanical income. And then you could get the covers for a successful song, third-party payments of their mechanical income. If there's a sheet music world here that still buys sheet songbooks for Dua Lipa, that means money. And if it makes its way to a Broadway production, that's a grand right. That's why people sue over these.
Let's turn to Mariah Carey, who beat a $20 million copyright case over her Christmas hit, All I Want for Christmas Is You. Was this lawsuit not based on the music, but on the words of the songs?
Probably the best question anyone's asked about that, because everybody kind of flips to the wrong page in that result. So let's go back to your question, which is just right on point. First, I don't often get to say someone's taking a hit at an evergreen hit. Evergreen hit, my pun there, meaning it's a Christmas hit, and you can't protect the title. First level of analysis, I'm not sure what people were thinking. We have the same title. Okay, that's not protectable, so there's where we start. And then the common elements, melody and other, were not here. Back to your lyric question. You want to hear what the common lyrics were? Try not to bust out laughing on this. I'm sorry if I'm insulting any attorneys on this, but get ready. Here are the common lyrics. Mistletoe, Santa, stocking, snow, and Christmas.
Oh.
Ooh. When you put it like that, ooh, that's not going very far. That is just not going to carry the day. You can't protect the title. You've got common elements in lyrics. You've got no question that you're claiming that the melodies are exactly the same. And here's sort of a sidebar moment. They claimed access and got the case rolling through the process in the court system because they claimed access that this had been a big hit in the country chart. I kid you not. Their song called All I Want for Christmas Is You was a country hit roughly the same time. So their access was based upon, it was a charting song. Whether a country hit gets listened to by a pop star and her co-writer, Walter Anastasius, don't know. But this one fell down the stairs pretty quickly in the Ninth Circuit in California because it wasn't provable. And I want to add also that sanctions and partial attorney's fees were granted against the plaintiffs on this.
Back to Dua Lipa for a minute. It sort of always surprises me that judges, and I don't know if this judge has any musical background or not, are able to come to these decisions, to figure out really the musical notes.
You're going to rely on the musicologist, right? Because the judges is going to make the decision based upon their own, even though judges in the past, go back to the George Harrison case with He's So Fine, My Sweet Lord, way back, the judge kind of said, hey, I'm a musician, I get this. That is actually a little bit of that case. And I've had judges in federal court who, kind of made reference to the fact that they played an instrument. Me as a musician, I don't get to testify. I'm the lawyer. So I can only use my musicologist, which I hope never gets that far, and it seldom does. I should say even more than seldom does. Rarely, if ever, does to get that far, because there's always this idea that what the judge is listening to are battling experts, right? And the judge gave, in this particular case, the judge gave credence to both sides and weighed it and said, look, I don't really find the access here, but so it's got to be strikingly similar. Your plaintiff's experts, they're making some good points here, but not carrying the day that they didn't get over the common elements of these two things. And the expert on the other side has said, look, these are really common, and was pointing to Mozart going forward. And I, in my amazing singing voice for you, said, it's da-da-da-da-da-da-da-da-da-da-da-da, right? And, that's ultimately what it came down to, is that these are common elements. And thank you for playing, but no, I'm going to dismiss it, give the summary judgment. And they rely on the musicologist to get there. But between you and I and anyone who might be listening to this, I think some of the judges quietly don't say it out loud, but they say, I have an opinion on this. I think there's something I want to probably, I have a position I'm going to take maybe on some of my own knowledge here, but they generally don't say that.
I expected more singing, Ron. You did da-da-da-da-da-da. That's not singing,
But June, that's the melody, right? I mean,
right.
The Dua Lipa part, and this is the thing about any time there's sort of hip-hop oriented or spoken word things, because the melodies can be, just the rhythmic. So in here, a lot of what the issues were rhythmic, right? The da-da-da-da-da-da. I'll stop. The lyrics really were not matching up. I mean, you just didn't have these common elements amongst lyrics like that. And then it fell really short on the Mariah Carey. I mean, it just didn't line up. And I think that judge clearly said, wait a second, you should never probably have brought this. Maybe one day we'll have professional juries like they do in some other countries with commercial work like this, where they are earning income and there'll be a professional jury, where we have not had that proposed yet. So here we are. It's going to be generally in jurisdictions where these cases pop up more often than others. Southern District of New York, Middle District, California, and the Ninth. So these are judges that have seen these, heard these, experienced in them, and I think you're getting a reasoned opinion on all of these cases.
Thanks so much for your analysis and your singing. That's entertainment attorney Ron Bienstock of Scarinci Hollenbeck. And that's it for this edition of the Bloomberg Law Show. Remember, you can always get the latest legal news on our Bloomberg Law podcast. You can find them on Apple Podcasts, Spotify, and at www.bloomberg.com/podcast/law. And remember to tune into the Bloomberg Law Show every weeknight at 10 p.m. Wall Street time. I'm June Grasso, and you're listening to Bloomberg.